Supreme Court in the matter of Securities and Exchange Board of India versus KISHORI Gupta allowed civil appeal and set aside judgment dated 2 August 2019 passed by Securities Appellate Tribunal, Mumbai. Court also said that mulcting SEBI with exorbitant costs payable to appellants is completely unsustainable. MS Vittal Communications Limited, New Delhi, was a public limited company whose shares were listed on Bombay Stock Exchange, Delhi Stock Exchange, and National Stock Exchange. While so, Securities and Exchange Board of India issued show cause notice dated 24 May 2005 to VCL and its promoters and directors under Section 11(4) read with Sections 11 and 11B of Securities and Exchange Board of India Act 1992 in relation to alleged misleading advertisements issued by VCL with regard to buyback of its shares, issue of bonus shares, and preferential issue of shares within 30 days. Details of advertisements published in newspapers between 27 May 2002 and 24 June 2002 were furnished therein, and advertisements were stated to be a ploy to mislead investors by benchmarking price of the scrip at rupees 30 when the share was trading at around rupees 3 to rupees 12. SEBI further stated that its investigation revealed that VCL had allotted 72 lakh equity shares of 10 rupees each at premium of 2.5 rupees, amounting to 9 crores on 14/12 1999 to 15 companies which had all given same address at time of opening their demat accounts. That apart, these 15 companies were shown as suppliers of VCL. VCL's funds were indirectly used for purchase of its own shares in as much as it gave advances to MS Anupama Communications Private Limited, MS CBS Systems Private Limited, which in turn gave trade advances to 15 companies. Thereby, same money came back to VCL as share application money. It was also alleged that between 2nd May 2002 and 31st July 2002, 71.14 lakh shares were sold by promoter related entities in market, taking advantage of artificial interest created by misleading advertisements. SEBI asserted that chain of events in respect of buyback of shares, bonus issue, and preferential allotment by VCL, along with unwarranted advertisements, suggested an orchestrated ploy on the part of VCL and its promoters to create artificial demand for shares of VCL and induce innocent investors into purchasing shares so as to absorb sales by promoter related entities. VCL and its promoters and directors were alleged to have violated regulations 3, 4, 5(1) and 6(a) of Securities and Exchange Board of India prohibition of fraudulent and unfair trade practices relating to security markets regulations 1995 along with section 77 of Companies Act 1956. SEBI therefore called upon addresses of the notices to show cause as to why suitable directions, including direction to restrain all of them from accessing securities market and prohibiting them from buying, selling, or dealing in securities for a suitable period, should not be passed under Section 11(4) read with Section 11 and 11B of the Act of 1992. Therefore, SEBI, speaking through a whole-time member, passed order dated 20 February 2008 in exercises of power under Section 11B of Act of 1992 and Regulation 11 of Regulations of 1995. SEBI dropped the charges against Vinay Talwar, former chairman cum managing director of VCL, and imposed a lesser penalty on Shubhna Jindal, director of VCL, where as she was restrained from accessing securities market and prohibited from buying, selling, and dealing in securities in any manner for 6 months. As regards remaining notices, VCL and directors and promoters, SEBI restrained them from accessing securities market and prohibited them from buying, selling, and dealing in securities in any manner for 2 years. Court said that it is not open to SEBI to claim that it could pass multiple final orders on same cause of action. Having undertaken exercise pursuant to show cause notice in 2012, SEBI passed order dated 31 July 2014 in exercise of power under Section 11B of 1992 Act with directions which attained finality and given full effect to. That being so, SEBI could not have reopened the entire exercise without just cause so as to pass a fresh order under Section 11B once again later after 4 years. Court also noted unconscionable delay on the part of SEBI, though whole-time member of SEBI passed order on 1st April 2016 requiring fresh re-examination and initiation of disgorgement proceedings. It was only on 19 January 2018, SEBI got around to issuing show cause notice proposing disgorgement and passed an order 7 months later. This laid back and indolent approach on SEBI in dealing with matters needs mention as it does not augur well for the statutory body enjoined with duty of protecting investors and regulating securities market, which is volatile, to drag its feet and indulge in unwarranted and unjustified delays. It was held that it was for the not for the tribunal to interpret earlier order dated 30th April 2013 and give it a different color contrary to its plain meaning. Finally, it had been contended before Supreme Court that SEBI has only four entities, including VCL, out of 22 entities filing appeal against disgorgement order dated 28 September 2018. The said order cannot be invalidated against those who had not chosen to file any appeal. Court was informed that some of the individuals concerned had expired, while most of the corporate entities had become defunct. In any event, as order suffers from inherent lack of jurisdiction, being barred for principle of res judicata, constructive res judicata, the argument could not stand.